Thanks, Dan. Thanks, everybody. Hi, thank you for joining us. Just our quick standard disclaimer, this presentation is for educational purposes only. It's not legal advice and does not create an attorney-client relationship if you're not currently one of our clients. Also, we're providing an overview today. This information is just sort of broad and addresses general situations. We're not really answering specific questions based on state law or anything like that. We're just giving examples of some of the scenarios employers run into. If you're already a client and you do have a specific question on one of these topics mentioned today or any other topic regarding employment law that you come across, send us your question through our portal. If you're not a client but you'd like help with some employment law issues, we'll have some information at the end on how you can sign up. As we always say, to help you get on with your day, we'll keep things moving as we go through this.
All right, question number 1. Do we really have to accommodate emotional support animals?
So this is a question we get fairly often, believe it or not. So is accommodation required for an emotional support animal? Well, the answer is, as it is with many items in the legal sphere, is it depends. So what is an emotional support animal? Well, that's an animal that's solely used to provide therapeutic benefit to their owners, such as well-being, comfort, companionship. In other words, it's used to help an employee feel better. That's the purpose of an emotional support animal. That's contrasted with a service animal. A service animal is generally a dog that's trained to work or perform tasks for the benefit of an individual with a disability. The difference between an emotional support animal and a service animal is that a service animal is a working animal. They are not a pet. The work or tasks performed by the service animal are generally directly related to the owner's disability. So that could be a guide dog helping someone who's blind, an alert dog who's going to help a deaf owner with different tasks, or a dog that is used to pull an owner's wheelchair. So what are some of the best practices as an employer when somebody makes a request to you to bring an animal into the workplace? Well, as a starting point, you're going to need to analyze each request on a case-by-case basis. That is true for both emotional support animals or a service dog. Each request needs to be viewed as a request really for reasonable accommodation under the Americans with Disabilities Act, which is a broad federal law, as well as, depending on the state you're located in, your state equivalent law to the ADA. So each request is really going to be viewed as a request for reasonable accommodation, either under federal and or state law. However, with an animal coming into the workplace, one thing to consider is it can't cause undue hardship to the employer. So what does that mean? Undue hardship means a significant difficulty or expense. So even if an employee can show the animal would be an effective accommodation for a person's disability, an employer could potentially deny the request to bring the animal in if it would cause a significant disruption to the workplace. So what does that mean? So if the animal posed a significant health or safety risk, for example, or if granting their request would otherwise impose a significant burden or cost on a particular employer. For example, if an employee worked in a clean lab at a biomedical facility, allowing that person to bring a dog to their workstation in the clean lab may be an undue hardship because it would cause significant disruption and burden on the employer. Another accommodation, instead of bringing in an animal, might need to be provided by the employer as a reasonable accommodation under the ADA. So if an animal won't work, there could be another accommodation. Under the ADA, an employee doesn't always get their preferred accommodation request. The employer just has to provide a reasonable accommodation. So if there's another accommodation outside of allowing an animal that would enable an employee to perform their job, then the employer could offer that other accommodation instead of bringing the animal in. For example, if an employee gets stressed out, they want to bring in their emotional support animal. Instead, an employer, as a potential reasonable accommodation, maybe would offer more frequent rest breaks for the employee to allow them to decompress. That could be an example of where an employer uses a different accommodation that's still reasonable versus allowing the employee to bring in an animal. And another thought to consider with an animal in the workplace is, as an employer, it's a good idea, if you're going to even consider it or look at it under the laws, to allow that on a trial basis. Just see how it works. That's one of the thoughts that has come through with animals in the workplace, is if you're going to give it a shot as a potential reasonable accommodation, do it on a trial basis first.
Question number 2. What steps should be taken when retracting an offer of employment?
Well, that's a question that we also see fairly regularly. You know, the employer has made an offer, and then for whatever reason that comes up, they don't want to move forward with hiring the individual. So if you're going to retract an offer of employment, can you do it safely in all circumstances? Well, the answer to that is maybe yes, maybe no. First, one of the things you want to look at is, why are you retracting the offer of employment? You don't want to retract an offer of employment for an illegal reason. For example, if your reason is, well, we don't hire anybody who's age 40 or older, or you say something like, well, we found out the person has a disability, or if an employer says something along the lines of, well, that individual follows a faith that we don't like, those reasons aren't going to work. That would be considered discriminatory, you know, not hiring somebody age 40 or older, somebody who's disabled, somebody of a different faith, because of those specific reasons. That's not allowed. If you're going to try to retract an offer of employment, it's best as an employer if you have a legitimate, non-discriminatory and non-retaliatory business reason for doing so. So what are some examples of that? Well, if somebody fails a background check, that could be a reason to retract an offer of employment. However, if doing it for that reason, there are some other steps you have to follow. We may not get fully into that today. Maybe somebody has a positive drug screen. Maybe they've provided false, information on their application and you discover it. There could be changed financial conditions of the prospective employer. You hired this person expecting a new client to come in, the client doesn't come through, your budget's different now, maybe that's a reason you retract, or the person's references don't check out. Another area to consider if you're looking at withdrawing an offer of employment is, did you use an offer letter? Using an offer letter is a best practice. If you're one of our clients, we do have a template available. And if you're using an offer letter, hopefully the letter will state, or has stated, number one, employment being offered is at-will employment. That gives you the most flexibility in rescinding an offer of employment if the person was made an offer of at-will employment. But even with at-will employment, you still have to have a legal reason for retracting the job offer. Again, it can't be based on something illegal such as discrimination or retaliation. The second thing that you want to have in your letter is that the offer is contingent on an applicant meeting several criteria. First would be like verification to work in the US, passing a background check, passing a drug screen, having references that check out, having them sign any pre-employment agreements, for example, a confidentiality document ahead of time. If your job requires certain physical activities, they need to pass a physical examination. They can verify that they hold certain licenses that may be required for a position, or they pass specific written examinations. So within an offer letter, again, you want to have a statement that the employment is at will, if you're an at-will employer, and then number two, that the offer is contingent on meeting several criteria. So what are some of the risks with withdrawing a job offer? Well, there's risk of a discrimination claim, as we mentioned, risk of a retaliation claim. Also, there could be what's called a detrimental reliance claim. And what that means is, if you're withdrawing an offer of employment, a person might try to claim detrimental reliance against you if they quit their current job and spent some money, say, on moving to a different location because they believe they had this new job based on the wording of the job offer. So that's why it's super important with your offer letter to have that buttoned down with your language. So some best practices to consider if you're looking at retracting a job offer, make sure that when you're deciding to withdraw the offer, it's based on business related criteria, not based on something illegal. Again, not discrimination, not retaliation. Use that well-drafted offer letter. that states employees are employed at will, and that the job offer is contingent on the employee meeting a number of conditions ahead of time. Using that good offer letter gives you written evidence that you're following the rules. It can help show that you did not discriminate, you did not retaliate, and that you did not set yourself up for a detrimental reliance claim.
Question number 3. What happens when an employee exhausts their FMLA leave?
Well, that's a great question. That's one we do see fairly frequently. Just as a quick reminder, the FMLA is the Family Medical Leave Act. That's a federal law that covers employers with 50 or more employees, and it provides employees who meet certain criteria with up to 12 weeks of unpaid job protected leave, maybe longer if the leave is related to certain military situations. But basically, for an employee's medical leave, they get 12 weeks of unpaid job protected leave off. They go through the 12 weeks, for example, and then you're coming towards the end of the 12 weeks, and the person, are they going to come back or not? Their leave's running out. What do you do as an employer? So as an employer, it is okay, and it's actually a best practice to communicate with the employee prior to the end of their FMLA leave. You can reach out in advance, send them an email, shoot them a text, ask about their return to work plans. If they're on FMLA and you checked the boxes on the forms requiring a fitness for duty requirement before they can come back, you can remind them that they need to provide a fitness for duty certification before they can come back. If you reach out to an employee prior to the end of their FMLA leave time and they don't respond initially, the recommendation is to try reaching out again, give them a call, send them an email again, send a physical letter, mail a letter to them if necessary. And as an employer, you want to keep a record of all attempts at communicating with the employee. If an employee ultimately doesn't respond and their FMLA is coming to an end or ends, then you can look at whether or not you want to move ahead with a termination based on job abandonment. In a lot of cases, obviously, you will get a hold of the employer or the employee and they'll say, yeah, I'm coming back to work. I'm coming back on schedule, for example. If they say that, great. Then you just, that's a good outcome, and then you just plan to bring them back at the end of their FMLA time. But if you get a hold of them and they respond, yeah, I know my FMLA leave's running out, but I'm not quite ready to come back. I'm still dealing with a health issue. Then you've got to check into the reason why, what's going on with that. There could be some state laws in place that provide additional time off for an employee beyond what the FMLA might provide. So again, that's a question if you're one of our clients to reach out if you're in that situation. Let us know which state the employee's in. That's something we can check on for you, because there are some states that may provide additional time beyond what the federal FMLA requires. And if an employee says they need more time off based on their own serious health condition under the FMLA, then you'll need to move into the ADA reasonable accommodation practice in most cases. What happens is once FMLA times out and they have this medical issue ongoing, and let's say there's not a state law that's in play, it's just 2 federal laws. Once the FMLA time is ending, the employee, again, is dealing with a medical issue that's affecting their return to work. Then you've got to switch gears and go to the ADA, the Federal Americans with Disabilities Act, and then you've got to get into the ADA interactive process and see if providing more time off for the employee will work as a reasonable accommodation under the ADA. Reasonable accommodation has to be provided under the ADA absent undue hardship to the employer. Additional leave can be a potential reasonable accommodation under the ADA. But one thing to keep in mind is if you're in this situation, again, somebody has used up their 12 weeks of FMLA time, they say they still need a little bit of time off afterwards. If you're granting additional leave as a reasonable accommodation under the ADA, that chunk of time you're granting does not need to be indefinite. It does not need to be open-ended. An employer can evaluate the length of leave requested by the employee beyond FMLA if that's going to be a reasonable accommodation under the ADA, to make sure it's not going to result in an undue hardship. That's just something to consider when someone's FMLA time is running out.
Question number 4. Can I terminate an employee who was arrested while off work?
Yeah, I don't know what happened at the end of this last summer here as we were coming into fall, but for some reason we got a slew of questions from many different types of clients around the country with this general question. So again, I'm not sure what was going on at the end of summer, but if you're looking at termination of an employee following their arrest, there are some factors that you want to consider. So can you terminate them? Maybe. The first thing that you want to look at is whether or not the employee is employed at will. We've touched on at will employment a little bit so far, but it's worth reinforcing because if your employees are employed at will, that gives you, the employer, the most flexibility with different steps you can take in any situation with an employee, including whether they're going to be disciplined or let go. So just a quick refresher, at will employment means that the employee is not subject to an employment contract. He or she doesn't have a promise of employment for a specific period of time, and the employee is not covered under a union collective bargaining agreement. So no employment contract, no promise of employment, no CBA. They're employed at will. That gives you more flexibility. With an at-will employee, they can be fired at any time for any legal reason. The termination just can't be based on something illegal, again, such as discrimination or retaliation. Termination also can't violate the law in a way beyond discrimination or retaliation. So specifically with an employee who's been arrested, take, for example, the state law in Wisconsin. Wisconsin has something called the Fair Employment Act. And that law prohibits firing an employee based on their arrest or a conviction record. So it's basically what's known as a fair chance law. But an exception under the Wisconsin fair chance law or fair employment law could apply if the conduct underlying the arrest is substantially related to the employee's job. So what does that mean? That means if you're looking at letting somebody go and you've got a fair employment state law in place, if the conduct underlying the arrest is related to the job negatively, then that could be an avenue for an employer to let an employee go who's been arrested. So what is an example of that? So maybe you are an employer that is a nursing home or some kind of senior care facility. If you've got a worker from your nursing home or senior care facility who's arrested for assaulting a senior citizen outside of work, an employer in that situation has an argument that the person's job is not protected under, say again, the fair employment law in Wisconsin, because it's so closely related to what the job itself is. Again, in the example, somebody works in a senior care facility, they're arrested outside of work, off duty for assaulting a senior citizen. That very closely ties to the job. And with those type of fair employment laws, such as the one in Wisconsin, that could give an employer an out to let the person go. Another thing to consider with arrests, if you're looking at letting somebody or kicking somebody out of your business, is a lot of times arrests, that's as far as it goes. The person may never be formally charged. If the person is formally charged, the case might not go forward any further than the charging. A lot of times cases are reduced, they're dropped. That's another factor to consider. It's better to have a business-related reason for termination that's been evaluated individually based on the circumstances. Overall, even if you're not in a state with a fair employment type law like Wisconsin, you do want to look at the underlying conduct of the employee that led to the arrest and how that relates to what your business does. Be aware again of those state laws that can limit an employer's use of an arrest or conviction record. Another area to watch out for with letting somebody go just because they were arrested is the disparate impact rules that are still out there in the law. What does disparate impact means? That basically refers to a person in a protected characteristic group facing more harm in employment, even under a facially neutral policy. For example, if an employer has a policy that says anybody who's arrested off duty will lose their job. Well, if that type of policy has a worse effect on certain people with protected characteristics, that could still come back on you as an employer in a negative way. Federally, the federal government is right now not pursuing disparate impact claims, but many states do still pursue those claims. And attorneys could, or an employee could hire a private attorney as well. So if you're thinking about letting somebody go just because they're arrested, the first step is looking at how you can tie that conduct underlying the arrest to the job itself.
Question number 5. My employee had to be let go, and I feel bad about it. Can I make sure that they receive unemployment?
You know, sometimes employers have to let an employee go because their performance is poor. And then sometimes in that instance, the employer feels bad about it. They say, you know, the guy wasn't working out, but we still had to let him go. I kind of feel bad. And I don't really want to mess up the person getting unemployment. I don't care if he can get unemployment. I kind of feel bad. I'm not going to try to stand in the way. So can an employer, quote unquote, make sure the employee will receive unemployment benefits? The answer to that is not really. That's because the state makes the determination on whether unemployment benefits will be awarded. It's not up to the employer, it's up to the state unemployment agency. And most states, when they're evaluating an unemployment claim that's been filed by a worker, they look at very similar factors to see from the state side if the person's going to be eligible for unemployment benefits. So one of the first factors they look at is unemployment through no fault of the employee. A worker is typically eligible if they're laid off due to downsizing, a lack of work, a company closure, something like that. A worker might not be eligible for unemployment if they quit their job without a good reason, or they were fired for misconduct. And misconduct could mean things like theft or violations of company policy. So that's the first factor. The second factor that needs to be met is the wage and work history requirements. Under state law with work comp, a worker must have earned a minimum amount of wages or worked a certain amount of time during what's called a base period, which is usually the first 4 of the last 5 completed calendar quarters before they can file their claim. So they got to hit that second factor as known here. The employee has to be, or the individual has to be able and available for work. So the worker has to be physically able to work and be available for a suitable job. The worker has to be actively seeking employment. Again, these are factors to qualify for UI. Most states require that a worker demonstrate that they're actively looking for a new job each week, although this may not apply if they're on a temporary layoff and waiting to get called back, which can happen in some industries. And then generally speaking, an employer has to be, an employee has to have legal authorization to work. So the person must be legally authorized to work in the US one way or another. Citizenship may not be required depending on the state you're in, but legal authorization to work in the US is something that could be looked at. So if a person who's been let go by their employer wants unemployment, the first thing they need to do is apply. They need to apply in the state system. And once their application is received, the state unemployment agency will inform the previous employer about the claim. So if you have one of your employees who's let go, you feel bad about it, they file a UI claim, you'll hear from the state. The state's going to ask about the work history of the individual and why they are no longer working. When the state notification comes in, some employers choose not to respond. The belief is that a non-response might help the former employee to receive benefits. Again, this is a situation where employer says, hey, I feel kind of bad, I let the guy go, I don't want to stand in the way of UI. So some employers, when they receive a request for information from the state due to the former worker's UI filing, they just don't respond. Could that help the former worker get benefits? Maybe, but it's not guaranteed. Again, the state's going to make the final decision. If the employer does respond to the state once they receive that notice of claim, any information provided by the employer, it has to be truthful. If the employee was let go for poor performance, for example, the employer chooses to respond to the state, that fact's got to be given. As an employer, you don't want to give an untrue reason. That can come back to bite you in many ways. If you're going to respond to a request from the state for information regarding an unemployment claim, you've got to be truthful in your response. Keep in mind too that a termination based on poor performance might not block the employee from receiving unemployment if the other criteria are met. So some states think that even if the person was a poor performer, that falls short of misconduct. Misconduct in many states is something more serious. It could be theft. It could be very strong violations of company policy versus, hey, the guy just wasn't doing a great job. With poor performance, some states might still award benefits because they don't consider that to be misconduct. So really, what's the bottom line? It's up to the state. Also, for the bottom line, be truthful if you're responding to the state with any information regarding a worker's claim for unemployment.
Question number 6. Can my employees accept gifts from customers, clients, vendors, etc.? Can they give gifts?
The answer again is maybe, under certain circumstances. A lot of what will go into an answer to this type of question from one of our clients will depend on the industry that the employer is working in. For example, if your business is involved with federal contracts, you are likely covered by the FCPA, which is the Foreign Corrupt Practices Act. That's a law, federal law, that prohibits the bribery of foreign government officials to obtain or retain business, covers anything of value. So with FCPA coverage, so if you have some federal contracts, the best number for a cap on an amount of a gift would be $0. That's to make sure that you don't run afoul of the law. Or if you're a business that's regulated under FINRA, the gift ceiling has to be $100 or less. So what's FINRA? It's the Financial Industry Regulatory Authority. It's basically a self-regulatory organization that oversees US broker-dealers and brokers to protect investors and ensure market integrity. So FINRA writes and enforces rules for the financial service industries. It looks at compliance. It administers tests, things like that. With FINRA, you're getting into the Securities and Exchange Commission compliance issues, SEC. So you're thinking about not running afoul of any federal financial crime rules. So again, if your business is subject to FINRA, you're looking at a gift amount to employees of $100 per person per year or less. What we see outside of federal contractors and outside of people under the FINRA umbrella is kind of a general guideline. Many employers say $50, many employees say $100. Those types of figures are fairly general, but really, if you're not highly regulated, as we had just discussed, looking at this as sort of a business decision for employers because of some different factors that can be in play. For example, maybe event tickets are coming and going. Maybe your business offers event tickets. Maybe you've got an employee that could receive event tickets. This can come up as a gift issue within a company for employees receiving gifts. Think of like a sporting event ticket or maybe another event like a concert. I mean, these days, any kind of sporting event or concert ticket is extremely pricey. That's not an unusual type of gift to be given, like an event ticket. However, if you're setting a dollar amount, it is likely going to exceed the $50 or $100 limit that maybe your company has. So some employers look at, depending on, again, on their industry, they look at maybe having a specific carve out for certain types of events. Another idea that many companies adopt just to be on the safe side is to have an approval process in place if an employee is going to be receiving gifts over a certain amount from an outside person, like a client, a vendor, something like that. So if it's anything over a limit that's been set by the employer of $50 or $100, maybe then before the employee can receive that gift, they need to check with somebody in management and get approval for accepting something that's out of the normal range. The other thing you'd want to keep in mind is that you need to be consistent with enforcement of a policy so that people are not favored over others in terms of the amount. If you're approving an amount, you want to make sure that you're consistent with that. The other thing is that you want to have a written policy to really help protect your company. Again, if it's something along the lines of a cap on a number that an employee can receive or give, because a lot of employers have a policy where they don't want their company to get in trouble based on the actions of an employee being overly generous with gifts. You can have a written policy in place. That's something that we have drafted for a number of clients, and we have it set up about giving or receiving gifts just to make sure that you're not running afoul or running into any issues depending on your industry or just the overall operation of how gifts are used within your company.
Question number 7. Can we use photos of our employees in our social media and for advertising?
Again, similar to the employee arrest issue that came up at the end of the summer into fall, this is also a question that we've seen kind of coming in from many different clients as the season kicked off into fall this year. So the short answer is you can likely use an image of an employee in your social media or for advertising if you first obtain consent from the employees. So why this matters is employees have rights. There's a right to privacy, and people have heard that term, but what does it really mean? So it broadly refers to protecting an employee's personal information and activities from unwarranted intrusion. The extent of that protection varies based on your location. In other words, some states have more robust privacy protection laws than others. But generally, a right to privacy broadly across the whole country means an employee has a right to access, control, and be informed about their personal data. They have a right to data privacy in certain areas like medical records and certain non-work related electronic communications. So employees have a right to privacy with some of their information, but in some cases at work, they may not have a right to privacy. Like, for example, employers may have a right to monitor employee communications on using employer-owned resources like email, things along those lines. But for the purpose of this discussion here, the right to privacy really is referring to an employee making an argument that they have a right of privacy in their personal image, meaning if someone has taken a photograph of them, their image, they have a right to privacy in that. Employees also have protection, generally again under state law, from misappropriation of their image. That doesn't just stop outside of work, it applies within work as well. So misappropriation would mean an employer using a name, an image, a photo, a video, a voice recording, or another likeness, quote unquote, of an employee for a commercial purpose without the employee's permission. So misappropriation could occur if there's not consent provided by an employee and the employer uses a picture, a video, a recording of the employee, say in a sales, marketing, social media, promotional campaign, something like that. Those are considered commercial purposes because those avenues used by an employer are to generate money for the business. They're commercial. They mean that you're reaching out to the public to generate business to come in. So that's something to consider. You've got to watch out and protect yourself from having a claim saying that their image is, an employee saying their image has been misappropriated. And then the right of publicity also comes into play as an employee right, and that's the employee's right to control the commercial use of their name, likeness, voice, and other identifying features. Where this really has come into play in the last few years is with college athletics. There's a lot of talk now about college athletes and their NIL rights. So NIL stands for name, image, and likeness. College athletes can now be paid for their name, image, and likeness rights and not lose their athletic eligibility at schools. Previously, they could not openly be paid for that. Now it's sort of a more realistic approach where schools and academic organizations understand these people have potential value in their name, image, and likeness, and they are able to, even while being on a school athletic team, capitalize on their rights. That's where you see some of these similar issues coming out in the public sphere. It's something you could also think about, however, the NL rights of your employees as it comes into business. So what about using an employee's name, image, likeness, other protected personal information internally only inside your business? You're not sending it out in a marketing email, for example. It's just internally only, maybe a company directory, something like that. There might be less risk for an employer in using an employee's photo or other image information only in an internal communication. But that's still something that is inside your business. Therefore, even if it's not shot out to the public, an employee might still have an argument that it's still being used commercially because it's inside your business. So even if it doesn't go out to the public, there could still be a risk. So what is the way for an employer to deal with this issue and help reduce their risk? Well, that's to obtain consent. If you get consent from your employees to use their name, their image, their likeness, a video, something like that, a voice recording that you are then going to use for your business, again, to grow your business, to communicate advertisements, to talk to vendors, things like that, it's best practice to have consent from the employee before you use that information from them. The consent should be in writing. It's also a good idea to use a consent form that's a standalone document. A blanket consent provision in an employee handbook example just might be too broad. It might not be specific enough if it's included with all this other employee handbook information. This employee right of privacy and right to control their image is such a big deal that you would want to have that in a standalone document that an employee signs that would authorize use of any personal image or other personal information that the company might publish for, again, advertising, marketing, vendor communications, things like that. A written consent form that you keep a copy of as an employer provides evidence that's going to protect your company. Hey, if the employee raises an issue about it, you could say they consented to this. Here's a copy of the authorization form that you signed. So proof of consent can deflect a later claim that the employee says, well, I never said you could use my image in that marketing post. So you could say, well, yeah, you've got a signed consent form here. Without that consent form that an employee has signed, there's always risk for an employer if they're using the employee image again in some sort of commercial purpose. And depending on which state or states where you do business, this can be even a bigger issue because some states have more protections for employees and the use of their image. Think of California, for example. So again, what you really want to look at is on the front side before using that privacy information from an employee, get the consent on the front side. So how are we able to help you with these questions that we see or other questions that might come up? Well, ask us. We're here to respond to your employment law and human resources related questions. That's what we do every day. Another good resource for you as an employer is our weekly newsletter. You're going to get all kinds of updates on all kinds of different law changes. This today was a sampling of some of what we see. Our weekly newsletter comes out on Tuesdays. And we'll have some information at the end on how you can contact us if you're not on the list to receive the newsletter. We can also advise you on the best way to handle these employee issues. Again, the ones that we just talked about today, yeah, they come up, but just think of all the other issues that could come up in your business relating to your employees. Even if you're in a situation that you haven't seen before, or you've seen it 100 times, it doesn't hurt to ask out, because there could be a change in law different from the last time that this issue came up. So you can always reach out to ask us a question. We can help with all of that information.